Start. If anyone else comes in late, that's completely fine. So good evening, everyone, and welcome at the very first event of our new Benjamin Ferencz Lecture series on international criminal justice. My name is Gabriel Kleveskaite, and I'm a researcher in international criminal law here at the Asser Institute, where I coordinate international criminal law-related projects, primarily focused on Ukraine, and also conduct research into fact-finding in international criminal investigations and prosecutions. The Benjamin Ferencz Lecture series on international criminal justice replaces what the familiar faces here will know as Supranational Criminal Law series that was running for 20 years. However, this year we had decided to rebrand it in order to make sure that the legacy of Benjamin Ferencz lives on and continues to inspire the generations of lawyers in The Hague. But now on to why we're here this evening. The legal principle of ne bis in idem, which doesn't sound the most exciting, or double jeopardy, proclaims that no person shall be tried twice for the same matter and acts as a safeguard against abuses of power and as a mechanism that promotes the finality and legitimacy of judicial decisions. It helps to ensure that once a matter is fairly adjudicated, individuals can move on without fear of facing repetitive prosecutions for the same conduct, a fear that could otherwise undermine the very fabric of justice. So at its heart, ne bis in idem is about fairness, legal certainty, and protection of individual rights. So while this principle protects individuals against overzealous prosecution, it also raises important questions, especially in the world where international crimes demand accountability across borders and jurisdictions. So you can think of a universal jurisdiction, different tribunals and courts that have been set up, as well as domestic jurisdictions stepping in more and more to prosecute international crimes domestically. So in this increasingly global and interconnected world, the application of this principle is more complex than ever before, and I hope it will be clarified. So tonight's lecture will shed light on these and other challenges, and I hope you will find it both enlightening and thought-provoking. I'm pleased that we have Dr. Gayane Nurejanian with us, who will give the keynote lecture tonight. She is a legal scholar from Ukraine and works as an associate professor at the Faculty of Law of UiT, the Arctic University of Norway. She holds an LLM degree from University of Cambridge and PhD in law from University College London. She has previously worked as a lawyer at the European Court of Human Rights and at the International Advisory Panel in Ukraine at the Council of Europe. She is also, related to the topic of today's conversation, the author of The Principle of ne bis in idem in International Criminal Law, a book that was released by Routledge just this year, so it's hot off the press. But before I give the floor to you, Gayane, I would also like to introduce our excellent panelists who will provide their observations on the topic following the keynote. We have Professor Roger O'Keefe, who is a full professor of international law and the chair of the International Law Group at the Bocconi University, where he arrived in 2018. He was previously Professor of Public International Law at University College London and Senior Lecturer and Deputy Director of the Lauterbach Center for International Law at the University of Cambridge. He is currently the Joint General Editor of Oxford University Press Series, Oxford Monographs in International Law. It's good to have you here. We have also Mary O'Leary, who is currently acting Principal Counsel of the Office of Public Counsel for the Defense at the ICC, where she's been since 2013. And prior to that, she worked on several defense teams at the ICTY, so a long stay in The Hague. And she also worked for an amicus curiae prosecutor and in the trial chambers. She's been actively involved in the Association of Defense Counsel for more than a decade, serving 2 terms as its president and currently as a vice president and its training committee. And last but definitely not least, we have Teodora Ugrin, who is Associate Legal Officer at the Kosovo Specialist Chambers, and before joining the KSC, she worked as an Associate Legal Officer at the ICC in the pre-trial and trial divisions. She holds an LLM degree in international law from Leiden University and a bachelor's from the University of Bucharest in Romania. So we have quite extensive practical and academic experience, which I hope will deliver a fruitful exchange. But we'll start with a keynote by Gayane, followed by the reflections on the topic. You can take the floor, and you will have 25 minutes. I will let you know when you have 5 minutes left. It's okay?
Thank you very much, Gabriella, for your kind introduction and for agreeing to moderate the event. And I also want to thank Asser Institute for hosting this lecture, to the panelists for agreeing to participate in the discussion, to the audience for being here tonight. It is an honor to be giving this Benjamin Ferencz Lecture. The topic of today's lecture is the principle of nebis in idem in international criminal law, and as has already been mentioned, the principle of nebis in idem proclaims that no one should be tried twice for the same matter. And that's also a topic of my book that is largely based on the research that I did as a PhD student at University College London. Gabriele also mentioned something about my background, and I think my background as a generalist public international lawyer who has gained practical experience in human rights and entered academia with the interest in international criminal law explains a bit a choice of the topic and the principle of nebis in idem, important human rights guarantee, but also of significance in criminal law, international law, as well as domestic law. But it also explains a little bit the approach that I take to this legal issue in my book, because I examine it from the perspective of from public international law and using the methodology of public international law. So the purpose of my lecture is to set the scene for the further discussion, and I'm not sure I will be able to clarify all the complex issues related to nebis in idem. I would probably rather flag out the problems that arise. So I will cover 3 points. First, I will start with some general remarks about nebis in idem in international criminal law. I will then provide an overview of the different categories of nebis in idem that exist in international criminal law. And then finally, I will focus a bit more on Article 20 of the Rome Statute of the International Criminal Court that embodies the principle of nebis in idem. So starting with some definitions. We've already mentioned what the principle of nebis in idem is about, and you will notice that I use the expression the same matter, so prohibition of the repeated trial for the same matter. And I use this generic expression because in the specific nebis in idem rules, the same matter can be defined either as the same conduct or the same offense. And you will also notice that I draw a distinction between the principle of nebis in idem, the principle that reflects a general value and idea that no one should be tried twice for the same matter, and specific nebis in idem rules, actually that give a concrete expression to this principle and define parameters and specific conditions under which this prohibition for repeat trial applies. I also, in my book, take quite a broad approach to international criminal law. So my book focuses largely on nebis in idem provisions in the Rome Statute and other statutes of other international criminal courts and tribunals, but my examination is not limited to that. I also look at the international law rules that are relevant for the prosecution of international crimes in domestic courts. So I also look at nebis in idem in human rights law and nebis in idem provisions in treaties that relate to cooperation and mutual assistance in criminal matters. So in international criminal law, thus broadly defined, the principle of nebis in idem is finds its expression in variety of nebis in idem rules. And I say variety because while all these rules reflect the same idea, their content, their substance, the scope of the protection from repeat trial that they offer individual actually varies. And Article 20 of the Rome Statute, to which I will return in my third part, is a good illustration to that. It's a provision that contains 3 different nebis in idem rules that differ in their formulations and their substance. There is no customary nebis in idem rule. So when states choose to respect nebis in idem, choose to respect the prohibition on repeated trial, there is no indication that they are acting because they believe themselves to be bound by the rules of customary international law rather than domestic law or treaty provisions. And what this means, particularly in the context of the prosecution of international crimes based on universal jurisdiction, that there is no general nebis in idem rule that would prohibit one state from prosecuting and trying the person for the crime for which the person has already been finally convicted or acquitted in another state. a state will be barred from thus repeatedly trying the person only if there is a treaty nebis in idem rule, if the nebis in idem provision, relevant nebis in idem provision exists in a treaty that is in force for that state. Why does nebis in idem exist as a treaty-based rule and not as a customary international law rule? In my opinion, one of the main reasons is that treaties provide more flexibility to the states. So nebis in idem requires that the state abstains from exercise of its criminal jurisdiction when another state has already exercised its criminal jurisdiction over the crime falling within the jurisdiction of both states. So the state has to cede, in a way, the exercise of its criminal jurisdiction to another state. And exercise of criminal jurisdiction is one of the core sovereign powers of the state. When the states conclude treaties, they can decide in relation with which other states the nebis in idem rules applies. And they can also have more flexibility with shaping the precise content of nebis in idem rules and even exceptions to them. So we see in treaties on extradition, on mutual assistance, that the states sometimes provide the possibility not to recognize the effect of nebis in idem of the judgments that relate to crimes against their national security or the crimes committed by their public officials. So what are the different types of these nebis in idem rules that exist in international treaties? As a starting point, the distinction that you may have already encountered is the intra-jurisdictional rules of nebis in idem and inter-jurisdictional rules of nebis in idem. Intra-jurisdictional rules, as the name suggests, apply within the jurisdiction of the same state or within the system of the same international criminal court or tribunal. One example of this internal intra-jurisdictional nebis in idem rule is nebis in idem provisions in human rights treaties. So Article 4 of Protocol number 7 to the European Convention on Human Rights is an example of intra-jurisdictional nebis in idem rule that protects the person from repeated trial for the same offense within one and the same state. And our paragraph 7 of Article 14 of the International Covenant on Civil and Political Rights is also formulated in a similar manner. So in human rights law, the person is protected, is not actually protected from repeated trial for the same offense in different states. And Article 20, paragraph 1 of the Rome Statute, the nebis in idem that actually prohibits the ICC from trying the person who has already been tried by the ICC itself, is also an example of intra-jurisdictional nebis in idem. That can be contrasted with inter-jurisdictional nebis in idem that operates between different jurisdictions. So between, for example, a state and international criminal court or tribunal. Paragraphs 2 and 3 of Article 20 in the Rome Statutes are examples of these rules. Paragraph 2 applies between the ICC and the member states, so state parties to the Rome Statute, and paragraph 3 applies between any state that has jurisdiction to prosecute culpable conduct and the ICC. The inter-jurisdictional nebis in idem rules can also operate between the states, so interstate nebis in idem rules. And here we also find different varieties of these rules because some of them directly oblige the state not to try the person for the conduct for which the person has already been tried in a different state. Article 54 of the Convention on implementing the Schengen Agreement is an example of such interstate rules. But we also find a different variety of nebis in idem rules. They don't directly prohibit repeated trial by the state, but they either mandate or give the state the option to refuse, for example, extradition request, or to refuse request for cooperation in criminal matters based on nebis in idem considerations. So extradition convention, European Convention on Extradition contains such a provision. An interesting example here is the recently adopted Ljubljana, The Hague Convention on Mutual Assistance, because here we have a so-called mandatory nebis in idem rule, which says that the state should refuse the extradition request if this extradition request relates to the person and the crime for which that person has already been tried in the requested state. Another interesting example of this type of nebis in idem in the Ljubljana, the Hague Convention, is this optional provision that gives the possibility to the states to refuse request for extradition or refuse request for mutual assistance in criminal matters if it relates to the crimes and the person for which the crimes for which the person has already been tried by a competent international criminal court. And that's a new variety of these nebis in idem rules that we see in interstate treaties. So while it is possible to single out different categories of nebis in idem rules, they still can vary in their substance. So in some treaties we see that the definition of what is finally tried is limited to the final conviction or final acquittal. In other treaties, a decision ending a criminal case with amnesty or pardon can be sufficient to trigger the application of nebis in idem rules. They also differ as regards the, for example, exceptions, whether they contain exceptions to nebis in idem. And by exceptions, I mean whether they envisage situations in which repeated trial for the same matter is considered lawful. So examples of the exceptions are judgments related to the crimes against national security or by the public officials or the crimes committed on the territory of the state. But as I said before, and this brings me to the third part of my lecture, Article 20 of the Rome Statute of the ICC is a very good illustration of this divergence and variety of nebis in idem rules in international criminal law. Article 20 has 3 different nebis in idem provisions that differ in their formulations, in their substance, and in the scope of the protection against repeated trial that it offers to the individual concerned. So what are some of these differences? And here I would like to point out 3 of those differences. The first one is their jurisdictional reach. So, as I mentioned before, paragraph 1 applies within the jurisdiction of the ICC itself. Paragraph 2 actually obliges the state parties not to prosecute the person for the crimes for which the person has already been finally tried by the ICC. And this provision applies or is directed only to the state parties, and it cannot do more than that because the Rome Statute as a treaty cannot bind third parties. While paragraph 3 is directed at the ICC itself and mandates the ICC to take into account prior criminal conviction or acquittal in any state that has the jurisdiction to try the culpable conduct in question. So you see the jurisdictional reach of these 3 different nebis in idem provision actually varies. These provisions also vary regarding as to whether they prohibit repeated trial for the same conduct or for the same offense. So those nebis in idem provisions that are directed at the court itself, so prohibit the court to try the person who has already been tried by the court itself or in another domestic jurisdiction, protects the person from the repeat trial for the same conduct. Whereas paragraph 2, the one that is directed at the member states, prohibits repeated trial only for the same crime. And the consequence of this is that the state parties to the Rome Statute or the nebis in idem rule does not prohibit the state parties to the Rome Statute from trying the person who has already been tried by the ICC for the same conduct characterized as a different offense. And that's an expression of the respect for state sovereignty, an expression of so-called reverse complementarity, where the Rome Statute does not do more than say that the state cannot prosecute the person again for the same crime, but the state remains at liberty. The state has the discretion to decide how do they characterize this conduct in their domestic proceedings. And these 3 provisions also differ as regards to the exceptions. So paragraph 2, the ones that I just mentioned, that is directed at the member states, actually is formulated as an absolute rule and does not have any reference to any exceptions. But we see that it does not provide an absolute protection from the repeated trial to the individual. Paragraph 1 only implicitly refers to the exceptions, and this exception is possibility to revise a final judgment of final conviction, a final judgment of conviction, and then we have paragraph 3, which I will believe we will discuss in the later discussions, and that provides exceptions, explicitly spells out exceptions and to the nebis in idem rule, and allows the ICC to try the case again, to try the person for the same conduct, only if the domestic proceedings did not amount to a genuine attempt to bring the person to accountability for international crimes. So the primary purpose of all these rules is to protect the person from the repeated trial for the same matter. But we see that because of the context in which they operate, the legal architecture of the ICC, there are other considerations that enter into play. And these considerations relate to state sovereignty or the need to ensure accountability for international crimes. And those considerations also affect the substance and the scope of the nebis in idem protection. In my book, I discuss or examine in detail how these rules work, what is their substance, what is the meaning of their different elements, and explain why their meaning and their substance differ. So to conclude, nebis in idem is an important human right guarantee and a basic principle of law, and in international criminal law it exists largely as a treaty-based rule. The substance of these rules can vary depending on the context in which they apply, and I think that investigating and understanding the meaning of this nebis in idem rule is particularly important now, because we see the developments related to increasing use of universal jurisdiction to prosecute domestically international crimes. We also see situations where domestic investigations are taking place in parallel with international investigations, and here I refer to the situation in Ukraine, for example, where we see domestic trials happening for war crimes while the ICC is investigating the situation, and we even see the possibility of establishment of new international criminal courts, such as the proposed special tribunal for the crime of aggression, which also leads to some questions about relationship between these newly proposed international courts and the ICC itself. Thank you for your attention.
Thank you, and thank you for sticking to the time this well. I think make easy job for the moderator. And thank you for your insights and for presenting your analyses, and I'm sure this has given some food for thought and maybe inspiration for reflections. So I will now turn to the panelists for your short interventions, and I will start with Professor.
Thanks very much, Gabriele. I'm going to address some of the things discussed in the early parts of Gajan's book, in particular the absence of a customary interjurisdictional nebis in idem rule, and the presence in specific sorts of treaties of such a rule. And I'm going to take it a bit further and ask, is there any chance of the development of a customary rule, and is there a chance of a more general insertion of such provisions in multilateral treaties? And my answer to both of those things is probably not. Now, Gajan mentioned, first of all, absolutely correctly, that there is, under customary international law, no prohibition on one state prosecuting a person, even for exactly the same crime for which that person has been prosecuted in another state. Fantastic example. Former dictator of Panama, Manuel Noriega, known as Old Pineapple Face to his poor oppressed people. He had terrible acne as a teenager and was teased someone who's teased at school either becomes a comedian or a military dictator. He chose the latter route, perhaps safer. Anyway, he was captured by the United States, placed on trial for drug smuggling and racketeering, and spent his time in prison, came out, was extradited to France, where he was placed on trial for drug smuggling and racketeering. Okay, no problem under customary international law. Okay, we do have some treaty embodiments of this thing, but what is very significant about these is that, with one exception, the very recent one that Guyane pointed to in the tongue twister Ljubljana-The Hague Convention, it's not exactly musical, is it? The Ljubljana-The Hague Convention, which is a general, potentially universal multilateral treaty. All the others are regional, and the strongest example are in conventions within the European Union. Okay, now I think that's significant, and I'll come back to that. Now, Guyane addressed, why is it that we don't have a customary rule? I mean, I actually think the reason is a bit more basic, but you nonetheless touched on something. I think the reason is simply also because there's not much of, this doesn't happen a lot, okay? Sure, we've always had nationality-based extraterritorial jurisdiction and so on, but the idea that you have so many overlapping extraterritorial jurisdictions is really a relatively modern phenomenon. And for example, so in the same way, for example, we do not have a customary hierarchy of jurisdictions. There is no reason why the territorial state has a greater claim, or the national state. Contrary to what some German professors say, universal jurisdiction is not a residual jurisdiction. It's every bit as primary a jurisdiction as any other, okay? Now, Guyane said states are attached to the sovereign elements in criminal law. That's right, but I think there's an external aspect of sovereignty that explains this very much as well, and that's the sovereign equality of states. Why should they get to do it and us not? Okay? It's the very same reason. Why should the state of nationality have a greater claim than us? We're equal. Okay? But it's even more so with an A bis in idem, because it's a complete accident that the person gets tried in one state first. So I think states actually think, why the hell aren't we allowed to do something which is our sovereign right to do, just because by some random chance another state with which we are equal does the thing first? That, I think, is the essence of the sovereign question. Now, why then do we have some treaty-based exceptions to it? Well, this is the interesting thing about the regional nature of these treaties and the fact that the really hard, direct, mandatory ne bis in idem is found only in some European Union instruments, including the European Arrest Warrant, and a handful of Council of Europe treaties concluded when the Council of Europe, okay, was a tight bunch before expansion in the East and so on. They trusted each other to an extent. And indeed, Guyane has a fantastic footnote, the ECJ, saying the reason why within the European Union we have this interjurisdictional thing is because states think, well, even though we might have done it differently and under different criminal laws, we can trust the others. And the bottom line is that beyond those very tight-knit groups, there just isn't the trust. States, okay, think, well, they might have let them off the hook, or they might have done this, or they might have done that, or quite simply, we can't trust those foreigners. Okay? And believe me, every state says this. Even states with the worst criminal justice systems in the world believe that their system is much better than everyone else's. Okay? So where does this lead for the possibility of a general multilateral treaty or a general rule of customary international law? Well, I think this militates very strongly against it. To overcome the insistence on the sovereign equality of states, the idea that, well, we've got every much right as they do, I think you really need a group that is bound closely through legal culture, through day-to-day dealings. I simply cannot imagine a more general idea that, for example, the United Kingdom would happily accept that a prosecution that took place in Iran bars it from prosecuting, okay? Or in Russia, or in somewhere else, okay? It's simply that states just don't trust each other to that extent. Could we think of a rule, either by way of custom or treaty, that might lend itself to a more general application? Perhaps something a bit like Article 23 of the Rome Statute. The idea that, yes, we allow them unless, basically, there's reasons for thinking that it was a fraud, okay? Even then, I don't hold out much hope. Why? First, it requires the state that wants to prosecute to assess the legal system of another state. And they're reluctant to do so. In fact, in the common law, there's the doctrine of the active state, that you can't. Of course, there are statutory exceptions. And so, for example, they commonly do it in relation to non-refoulement. We can't send them there because they're going to get an unfair trial, etc. And what happens? The other state goes crazy. Every time one state doesn't send someone back to Rwanda because the Rwandan prisons are bad or whatever, Rwanda sends a protest and, takes it to the African Union or some such thing. So states themselves feel nervous about it, but even more so, they don't want, like Rwanda, their own system being judged by another state. Now, they hardly want the ICC to judge it, but they kind of think, okay, that's an international tribunal, we'll cut them some slack. I'm not sure outside of a tight regional group whether they would think that and be happy to have their own legal system examined in detail, for its fairness and for this and for that. We do have the Ljubljana, The Hague Convention, which has the second sort of mandatory indirect thing. I think that's probably the best we can hope for. The idea that if the state wants you to extradite the person to them, if you have prosecuted, then you don't send them. Because that way the state doesn't have to analyse any other state's system, and they don't have to have theirs analysed. So I think this has been very, very cleverly drafted in the Ljubljana. They should have drafted the title better. The provisions are fine, okay? The provisions are fine. The Ljubljana, The Hague Convention. So we wait to see what happens in that regard. But I think that is a promising sort of avenue, somewhere where the state doesn't have to judge anyone else and doesn't have to be judged, but nonetheless there's a form of ne bis in idem protection in that regard. So I think Guyane has done a great service in showing the three different things and highlighting yet more complication of the principle of ne bis in idem as much horizontally as what we're about to hear vertically. So thank you.
Thank you, and thank you for already making an inlay into our second panelist. Again, I will give you time after all the panelists to respond to any of the observations. Mary, please, you have the floor.
Thank you. And thank you for having me here today. Of course, I have to start by telling you, with regret, my views today do not reflect the views of the ICC. Okay, they're mine. So if you have an issue, you take them with me. Good. Because I want to focus on the defendant in these proceedings, because it's great what the states want, but we're talking about a specific defendant in the trials, and what's right for them has to be considered, of course, to some degree, at least from my perspective. So I met Guyane at a conference last year, and I thought she was so sweet because she brought me a bar of chocolate. Okay, but also because she entertained a real pet issue for me, which is ne bis in idem in international criminal law. I started ranting about it, and she said, "That's what I'm doing my PhD on." And I said, "Yes, good, thank you." Because one of the things that I think we need is this. We need a start, and we need a discussion to talk about it, because we can't get to a general idea or some sort of consensus if we don't actually discuss what it is that we're doing. So this is a capital start, just having it. So congratulations on that. But I also then opened it and read it, and even more thrilled, I have to say, when I got to it. Because I am probably an outlier, but in my position and in my beliefs, I think that ne bis in idem at an international criminal court or international criminal tribunal should bar prosecution anywhere else for the entirety of that conflict situation, the parameters of the jurisdiction. And I'm not the norm, I have to say. A lot of people would say that's not fair, because what about victims in other incident sites? What about things that are not charged? I understand this. But there is also this right to legal certainty. There's this right to have it end. And there's a variety of factors in international criminal law that are actually distinctive, that make it somewhat different from one trial in one state and another trial in another state for the same. And in the book, there is a part where she actually defines, why. And the core being, why do we have this rule at all? And I found it somewhere in the middle. Page 65 says, the rationale for the rule, which in part is to spare the person the strain and cost that repeat criminal proceedings would entail, and to secure him or her the freedom to move on with his or her life. And it's in this part about harmonizing, and it's sort of, I'm taking it a little bit out of context of the discussion here, but that's it. So that once you do the trial here, which we know these are complex trials, huge trials that take a lot of time, it's done. For that conflict, it's done. And that's why I take that position. So I was happy that the rationale was there. And I also loved that in this, she starts looking into, of course, the prep documents, as we always do, when we look to how we got to somewhere in the Rome Statute. And it was a song that was, quite familiar in that, there's a footnote that says, one delegation wanted this, one wanted this, they couldn't agree. This is what we went with the word crime going forward. But it says, we'll have to discuss it in the future. This is the future. We're here now, 25 years later. And I think that, again, starting this conversation now to have this is the important part of developing it. And it's not that nothing's been done in the meantime. There have been cases, of course. One of the most notable is the Katanga case, when we talked about this in the context of Mr. Katanga going back to the DRC, and the DRC saying, actually, we have these new charges now for you, but it's within the same conflict. It's a little bit distinct because it's a provision that they did it within a period of time that they should have waited 30 days past in Article 108. But the finding still on ne bis is relevant and discussed in the book, to which the Chamber says that the position advanced by the defense team of Mr. Katanga, which considers the entire ambit of the investigation, if that were included in ne bis in idem, would have the result of the choices of the prosecutor following the referral of a situation to the court to shield individuals subject to investigation from domestic prosecution for other crimes, including crimes of potentially equal gravity. And I agree, especially when they're talking about the sense of what the limits of the law that they have in front of them is. I agree with that. And I agree if the full trial goes through. But if we're just talking about investigations that fall away, maybe not. There's a couple of things here too. The book really highlights sort of this defining sameness. You said the same matter, which I like the same matter better than crime or conduct. Conduct actually sits okay with me when we're talking about the conduct of the person, because we're talking often about complex crimes and complex modes of liability. For example, joint criminal enterprise or co-perpetration. Should you be tried again for that same conduct you had in a different incident site when it wasn't covered by the prosecutor? I'll say that I just wanted to highlight, because I know I'm pretty short on time, but the differences here for ICL that I promised to discuss are this. One time. Somebody who sat in a trial for 10 years should have some finality of that part of their life, especially when we look at a sentence could be meted out for decades. And wait, you also have a reparations order against you for, say, $50 million. Should you, if you manage to overcome all of this, then be subject to proceeding in Germany, who's decided to on one incident site, or one in, your home state, let's say. To continue to replicate this to cover all of the victim bases, I don't think is very fair to the defendant. Caveat, but what about the victims? Now, I'm not going to get into that, but that is the issue too, where we have at the ICC, having the reparations hinge on that conviction for those incidents, and then not being eligible for reparations if your incident site isn't included, creates this issue that there is a need probably somewhere else to have some sort of relief because your specific crime has not been covered here. And so I think that that part of it, there's all of these embedded issues that we need to look at and sort of think about purpose. Reparations and fixing maybe that so that it's a wider bucket of reparations might also assist in this. But we know also then with timing, after the Milosevic case, they said we've got to make these smaller. We've got to pick your most representative incidents. It doesn't mean that they're not all considered. And there's a lot, because we're talking about widespread and systematic. We're talking about armed conflict. And so that whole area of the jurisdictional parameters, to me, is considered. You know this when you look into any judgment and you see the whole history of the conflict, the history of the area often. And every part of it, you have unindicted incidents sometimes discussed in there. They're not actual charges, but they're litigated heavily sometimes as a part of this widespread and systematic. So the fact that that all comes into play, going through it again in another trial, in another venue, might not be fair to the defendant. Again, this rise of legal plurality that we're talking about, it just didn't exist in the same way that we have now. Guyan said at the very beginning, universal jurisdiction it's proliferating, it's blowing up. People are using universal jurisdiction. And so if you do that in conjunction with these international courts that you have, you're going to see it more and more, as you alluded to. But one of the other novel features here when we're talking about time is that these crimes have no statute of limitations. And because their universal jurisdiction can be tried absolutely anywhere in the world, in practically any court. And so that's where you can see, of course, this continuing punishment. So I guess there's other issues that I won't have time, but if you want to talk about also retrial within the same institution, that's another one that comes up. But I think the discussion is right. I'm happy that this book is here, and I guess, dovetailing off of your question, getting a plurality of states, do the ICC states as a group, can we have the discussion there to create this customary international law that could be proliferated across jurisdictions? Whether people accept it is another story, but could we start the discussion there to have some sort of effect?
Thank you. Thank you, Marian. Thank you for bringing us back to the rationale and also into the courtroom and the experiences of the defendants, which is a very important perspective on the micro level. Theodora, please, you have the floor.
Thank you, and thank you very much to Gane for the invitation. I wanted to focus this evening on the exceptions to the nebis-idem principle that are under Article 20, Paragraph 3 of the Rome Statute. That is, when the court can try a person who has already been tried before another domestic court, if, and there's two specific scenarios, that if the proceedings before the national court were not conducted with a genuine intent to hold the person responsible or to otherwise bring the person to justice. Why did I want to focus on this topic? Because I think that it has the potential to generate questions and to be increasingly relevant in the practice of the court in the coming years. In the early situations before the court, we saw a sort of agreement between the states and the ICC, and I'm thinking of the Uganda situation, the DRC, where the state welcomed the ICC's intervention and exercise of jurisdiction. That's not something that we'll necessarily see in later situations. For example, Venezuela, Philippines, Afghanistan, where the court's intervention is not welcomed. And I think there's going to be questions that arise from this tension between the ICC and states, if I can call it like that. Guyana already very nicely engages and provides answers to some of these questions that may arise for the court. and maybe others we can also address during the Q&A later. I will focus on 3 of them. The first one is, to what extent can the ICC look outside of the actual case file that comes from the domestic proceedings? Meaning, to what extent can the ICC look not only at what the state has done, but what it has not done? Have key witnesses been interviewed and their evidence secured, or has evidence been ignored? Have forensic expertise been conducted before the evidence is lost? And Gayane addresses this question, and she says that indeed irregularities in the investigation can signal a lack of genuineness on the part of the national authorities to bring the person to justice. Now, my second question is, let us assume that indeed the national proceedings are conducted with a genuine intent. But there is another actor in the state or another institution that is interfering with those proceedings and with that process, and that is done with the intent to shield the person from justice. It may be direct intervention. For example, witnesses are being threatened or pressured not to give evidence, but it can also be a more indirect form of interference, not providing sufficient funding or resources for the investigative authorities to actually do their job, not having a robust witness protection program that then allows witnesses to come forward and give the evidence, or not ensuring that the judges are independent. And then I have 2 questions for Gayane that maybe we can come back to later. One is, to what extent can the ICC look into the entire functioning of the judiciary of a state? And I know that you do not always necessarily take the same positions as ICC chambers, so I want to hear your view on this. And the second question on this is, how does Article 20, paragraph 3 apply when the state does not act as one block, where we have different actors with different intentions, some genuine and some not? And my last question, or my last point is, again, we're in the scenario where the national proceedings are genuine and the person is brought to justice, but then the sentence is not enforced, either because there's an amnesty or a pardon or commutation of sentence. And again, Gayane addresses this question really head on, and you take a very, very clear stance on it, which is that, and correct me if I'm wrong, the passing of a pardon or an amnesty does not necessarily allow the ICC to retry the person for the same matter, unless the entire proceedings were not genuine. And I wanted to maybe trigger you a bit on this, so also for the benefit of everyone in the room, if you can explain why you take that view and what is it based on. Because we have read it in the book, but also for the public.
Thank you, and thank you all of the panelists for brilliant interventions, and I think we have more topics than we can cover in a few days' event, so I will let Gayane be picky and respond to the panelists' observations.
Thank you very much for your thoughtful and insightful comments. Marie, you're right that I wrote this book with an intent to tell the story of how nebis in idem functions, and it is a starting point for me. For me, it was nebis in idem is a complex already notion, and the rules differ so much. So my aim was to have a book, have a work that actually tells how this principle functions, and then have it perhaps as a starting point for a discussion. Something that I don't address very much in the book is whether we should have a different nebis in idem at the ICC in the context of international criminal law when we have such complex cases of criminality. So that's another kind of thing that I've been thinking about since I've published this book. But I will return to comments, Roger's comments about nebis in idem and its absence in customary international law. And I agree with you that, yeah, there are very little prospects of an interjurisdictional customary nebis in idem rule. And actually, for me, the fact that the Hague Convention did not include this direct nebis in idem rule is also an indication of that perhaps was difficult for the states to negotiate, and that's why it was limited also for the reasons that you highlighted to this indirect mandatory and permissive nebis in idem rules. This I also thought about the Council of Europe conventions, because one of the strongest interstate nebis in idem rules is contained in the European Convention on International Validity of Criminal Judgments. And this convention was adopted in 1970, but only 23 states have ratified it. So that also tells us something about perhaps reluctance of the states to recognize the rule. So there is, I agree with your comment about this regional instruments which are perhaps a bit more strong on this nebis in idem rule. Yeah, and returning to Marie's comments about the defendant's perspective, you spoke a lot about Article 20, paragraph 2, so the rule that is directed at the state parties of the Rome Statute, and that rule, as I mentioned before, actually allows retrial for the same conduct characterized as a different crime. And in the book, I explain why it is the case and that it's part of this reverse complementarity and the state sovereignty. But I also have a section where I actually questioned whether perhaps there are good reasons to rekindle this balance in that specific rule between the state sovereignty and the individual interest, because now we have seen how complex these trials are and how long they last. And if we have a conviction at the end, the ICC allows victim participation, so the people who have been affected, who have been harmed by the crimes can have a say, can get a reparations. But if we have an acquittal in the end and we have a rule that actually prohibits retrial for the same conduct in the domestic courts, that can also perhaps affect which prosecutorial strategy is chosen and whether the prosecutor actually decides to go on with the investigations, because the acquittal would mean that no one can prosecute afterwards. So I wonder if that could also have an impact on the quality of the trials. I'm not sure about having a rule, a nebis in idem rule, that would bar repeated trial for all the crimes, for all the ambit, because I think that's not longer the function of nebis in idem. You know, the rule exists to bar repeated trial for the same matter for which the person has already been tried and convicted. So perhaps other issues, other principles and rules can have a role here. In common law jurisdictions, you have this idea of abuse of process, that if you could have investigated the things together in one trial, you should have done it. So I wonder if there are other rules that can play a role here. And I think the fact that the Rome Statute uses the expression same crime or same conduct, but in practice the ICC has adopted this substantially the same. So I think in practice they have at least expanded a little bit, made this criterion a bit more flexible, that allows to compare at least whether the crux of all the charges are the most serious incidents. So I think taking into account the language of the treaty as a starting point, we already have a better or a more flexible rule that it could have been. And that's a theme in my in my book that I interpret the treaty, I look at nebis in idem, I recognize that its primary rationale is to protect the person, but I interpret the treaty. So for me, the rules of interpretation of the treaty are an important tool, and the language, the terms of the treaty is always a starting point, and sometimes I also look at the preparatory works. And that also brings me to your points, Theodora. There is not much practice on Article 20, paragraph 3, and whether the court can look on what steps are taken in the domestic investigations. I think yes, because the court does that already for the purpose of admissibility. So when they look whether there is investigation, whether it's a genuine investigation, they look at what steps are taken by the domestic authorities, and whether the court, what happens if you have interference from other executive, for example, into the judiciary work. I think the language of the provision actually allows to look at it, because paragraph 3 says, talks about otherwise not investigated impartially or independently, and if we, in accordance with the relevant human rights standards. And relevant human rights standards, I think, are relevant here because you then in human rights law look at what is independence, and independence is defined also in terms of relationship with other branches of power. So I think that's actually why I think the independence and impartiality in accordance with human rights standards has been added as an exception in Article 20, paragraph 3. And the question of the sentence, again, I take this view that failure to enforce the judgment itself is not a basis for the ICC retrial, unless it's the outcome of a sham trial. And that is based on, again, the language of the provision that talks about the proceedings in court proceeding in another domestic court, and a question or the decision on pardon or commutation of sentence is usually taken not within the proceedings that are related to accountability for the crimes. It's a different stage of the proceedings, or it can be taken by the executive. So for me, the language of Article 20, paragraph 3 does not support this reading, even though it can make sense from the perspective of accountability. And another reason is that I looked at also preparatory works, and there was an idea to include actually non-enforcement as one of the grounds for repeated trial, as giving the court competence to retry the person if the state fails to enforce the sentence, but they didn't manage to agree on that, and I think it also tells something about the intent of the drafters of the Rome Statute and how we interpret the provision. And I think more generally, perhaps they didn't agree because the states didn't agree because they wanted to leave themselves some kind of flexibility how they deal with transitional justice, reconciliation matters. So that's the reason I take this stance. Thank you.
Does anyone on the panel have follow-up questions or reflections? We still have some time.
I don't have a follow-up question. Just to what you might call points of information. Interestingly, in the European arrest warrant, one exception to ne bis in idem is where the sentence has not been enforced, which actually strengthens your argument in a sense, because they had to specify that explicitly, that was a ground, rather than that was included within the general principles, so that they distinguish clearly between the court, and then they have to go the extra step and say, or if the sentence was not enforced. As to statute of limitations, there's actually no customary rule which says that international crimes may not be time barred. Now, and in fact, many states do have statutes of well, those that have statutes of limitations, many do impose it in relation to all crimes. Now, how that plays out in terms of certainty or whatever, but I guess that lends a certain certainty to some people. Of course, you have to remember that in the vast majority of the common law world, there is no such thing as limitation of crimes. So it's, maybe no statute of limitations in a way is kind of, has a perverse effect of then creating this uncertainty as between international and national, although in the end I think probably it's, it's going to be a tiny number of cases, isn't it, ultimately? That do you change a whole rule just because of a tiny number of cases? So, yeah.
I don't disagree on that last point. I do think we have had a tiny number of cases that we know about, and I'm going to focus back on the international criminal law sphere because that's all I know. But there have been, there's, I think Theodora nodded to the growing, to the ICC will see more of this going that way, going up. But, from the ICTY perspective in working there were a lot of times when people would be done with their trial at the ICTY, and then the regional war crimes chambers would also have cases against them. And while they might not ever go forward on them, it did have limitations on them then. Obviously it restricts your freedom of movement. It causes maybe more legal, challenge that you have to do, more legal bills that stack up and more of your life in challenging, just actually going into, trying to show that it is the same case in some way. And so, again, having that universal jurisdiction sort of proliferating and other states maybe cropping up and doing this, having a common understanding of what are we talking about? Same crime, same conduct, same matter, when we're talking about this plurality of not necessarily state to state, but on these ICL ones, I feel like it requires just a little bit of a distinction. But again, this is my take on it. And for the victim side of things too, I think that's one of the pieces of the puzzle we have to figure out, because we have to use the whole battery of transitional justice measures, as you just said. I mean, criminal trials are just one part, and there has to be a way to get some sort of restitution to victims that doesn't necessarily come within these trials, because I think that's expecting too much, and maybe looking at that part would alleviate the issue and the need to have the trials proliferate.
Okay, that's a good point.
No? Go ahead. All right. So then I think I will open the floor to the Q&A with all of you. And there is a microphone in the end with our intern, Konstantina Karakuni, who will walk up to you if you raise your hand. Just as a note, this event is being recorded, so if you ask a question, you will be on the recording. So that's just for you to know. And I think I will abuse my position as the moderator and ask the first question as you can think of your own. Panelists are also still welcome to ask questions too. I was just thinking while we're discussing all these matters of growing universal jurisdiction, potentially another tribunal for Ukraine, the ICC jurisdiction over Ukraine currently still not a full member state, thus potentially not bound by some of these provisions in the statute, though they are on the way, but they have been on the way before, so let's see how that goes. What do you foresee in terms of how the national jurisdiction of Ukraine might be interpreting this principle, especially in cases where they may be, let's say, dissatisfied with the type of charges that were brought against the defendant? For instance, now we have war crimes charges, right, for the transfer of children. What if they are not satisfied that that is enough and they want to address different conduct? Do you think that can also, if there is a full understanding in Ukraine, which I doubt that there is in the government levels, that by signing on to the statute, they might now be bound by the nebis in idem rules that the statute has? Would that also be something to calculate into the equation of becoming a member state? So it's a double-barrel question, actually. I'm sorry. Just go on.
I think there are so many different crimes committed in Ukraine that I think Ukraine would be content with some of them being taken by international criminal court. And I think in Ukraine there is still a lot of respect for international judicial institution, be it International Criminal Court or the European Court of Human Rights. Actually, the jurisprudence of the ECHR is very important in Ukraine and has positively affected the Ukrainian legal system. And I think we can see the same attitude to the ICC. And Ukraine has been pushing for the ICC's involvement and welcomes ICC involvement and cooperates with it. So I don't. There may be some dissatisfaction about the specific charges chosen by the ICC, but I don't see that there will be actually prosecutions or against the same defendants, especially because Ukrainian criminal code does not criminalize crimes against humanity, right? And that's why most of the prosecutions are on war crimes, and that's also the charges. Most of the charges relate to war crimes that we see at the ICC. So I'm not sure to what extent the government understands what are the consequences of ratifying the Rome Statute, in particular with regard to nebis in idem. But my impression is that given how closely Ukraine cooperates with the ICC and that Ukraine wants to see involvement of international institutions and accountability on the international level, and there is so much other work to do for the domestic trials, I don't think there will be any conflict there. What I see happening, maybe there can be some trials in Russia, for example, and then the ICC would have to evaluate this under Article 23 and to what extent these trials are genuine.
Yes. And of course, it depends on what gets delivered by the ICC in terms of the expectations that Ukraine has for the cases, but that's for the future. I saw some hands. Can we collect a couple of questions? Yes, in the back.
Hi. In my home jurisdiction back in the United States, we have what we call the Brubacher test, which is if the elements of the crimes are the same, then you can't be prosecuted by the state and by the federal government at the same time. You're barred either or. So with the idea that the state parties to the Rome Statute are now all adapting and adopting domestic laws that reflect the same crimes that are covered by the ICC, can this be used then as another point of analysis when it comes to double jeopardy between a state party and the ICC? Basically, you would have comedy, but you would have, we use all the same elements, so we can't go forward with it.
Thank you. Rasik, another question? Here, I think. Yeah. Yes, go ahead.
Thanks. Just the discussion now brought me to the discussion on the Palestine arrest warrants and the discussion of whether the ICC jurisdiction is delegate or not. And in that sense, I wanted to ask if a state would consider, given that it has acceded to the ICC jurisdiction, even referred a case to the ICC jurisdiction, if a state should consider that judgment as its own.
Do we have any more at the moment? Yes, one more, and then I'll give you a turn.
Thank you. My question is about sources. So much of the discussion about the origin of this norm, of the principle of nebis in idem, was based on customary international law and treaty rules. My question is whether you could consider it a general principle of law, because if so, it would be relevant under the ICJ statute, Article 38.1c, and the Rome statute, Article 21.1b. Thank you.
Thank you, Graham. I'll give you 10 seconds.
Thank you for your questions. And starting from the first one on implementing legislation, what matters for the for the rules where the ICC has to look at what has been done at the domestic level, it's sufficient that the conduct is prosecuted regardless of how it's characterized legally. So if the conduct that forms a base, that amounts to international crimes is prosecuted by the state even as a crime of murder, for example, under domestic law, that's sufficient to trigger the application of nebis in idem rule. What I think is interesting with the domestic implementing legislation, that's something I also wanted to mention in replying to Marie's point, that there's example of Australia where the implementing legislation actually says that we are not going to prosecute the cases that are the cases that have already been tried by the ICC. So they also have it in the domestic legislation in a way of recognizing the effect of the ICC judgments. And there are also some domestic jurisdictions, I think including the Netherlands, which in their domestic law recognize the nebis in idem effect of judgments delivered in a different state. So that can also be another way if we don't have the general customary rule of nebis in idem for the states to provide a nebis in idem protection in their domestic law. And whether the states should consider the ICC judgment as its own, I'm not sure I understand the question, but the state, well, the example of implementing legislation where the state can adopt a rule recognizing the effect or the recognizing that it should it will not prosecute or try the person that has already been tried by a competent international court. And the question regarding the sources, I actually didn't touch on this issue, but I argue in the book that nebis in idem, at least in terms of the general proposition, can be considered a general principle of law. And some of the examples of application of it as a general principle of law to me is practice of the ICTY, because the statute of the ICTY does not contain an internal nebis in idem rule, only those that operates between the ICTY and other national jurisdictions, but they recognize that the rule or the nebis in idem applies, and I think then the source here is that it's a general principle of law to me.
Let's pick up that last bit. I mean, this is the key distinction between a general principle and a specific rule. If there's a general principle, it's that the same matter shall not be tried twice, which doesn't tell us anything. What's a matter? Because there isn't a specific rule common to legal systems, and this has been emphasised in the ICJ itself. I mean, Lord McNair in the South West Africa cases, that a general principle doesn't transpose lock, stock and barrel a specific rule from a specific jurisdiction. So yes, it's a general principle. That doesn't necessarily make it helpful because it doesn't answer the key questions. Is it a crime? Is it the conduct? Is it this and is it that? So yeah, you might say in very general way, like equity is a general principle. Well, where does that take us if we're looking at specific instantiations of it? So there is a temptation, I find, which kind of frustrates me. People looking for a rule. They don't find it in a treaty, they don't find it in custom, and so they magic it up out of general principles. But hang on a minute. If the specific positive sources don't embody the specific rule, you can't say, well, we lack the specific and therefore we fall back onto the general. No, it works the other way around, you know. So, yeah, sure, you got a principle, but that doesn't advance things. But, yeah, it's a great question.
Yeah.
But you deal with this, don't you?
I deal with it in my book. I have, I go through the general principles, and also because I have also a comparative section which looks at different constitutions and criminal procedural law.
I think you did the Brubaker test as well. It's in the
Yeah,
book.
that's also in the book. So where I try to show, I kind of have this chapter to show then why it is, I think it is a general principle of law, because you have so many domestic jurisdictions that recognize or have this recognition of the value at least. But I wonder also if we can encounter the situation in which a person or a defendant can argue to the state that, look, there is a general principle of law, and a state that is perhaps, I don't know, particularly human rights abiding could say, okay, because there is this general principle of law, we abstain from prosecuting the person. It's not a rule, it's not an obligation, but if anything can be used in this argument, I think the general principle.
I think that's to turn things on its head, because general principles are abstracted from specific rules at the national level. And so they will say, well, you don't then reintroduce at a more abstract level into the domestic jurisdiction from which it's been abstracted. So if there's no rule, there's no rule. But you never know, I mean, there's a lot of confused judges out there. So
Creativity. Do you have any other questions? Yes, please.
I'm not an expert of Article 20, so if I sound like a fool, I'm on tape about it. So, so I'm just wondering.
Wipe it.
There will be traces of it.
after.
Yeah, whatever. I'm doomed anyway. So I'm wondering if we look at it more in a way that, because it's really hypothetical. I don't think it's something that we have seen before, but where it can be used at the advantage of the defendant. In a way, in a way that you have been persecuted in a state, two states had an armed conflict, and you end up on the wrong side of the border, depending of what was your position. You're being persecuted in a state, and you claim that it was unfair. The trial was rigged, and you have been found guilty. And for whatever the reason, through referral, whatever, the case arrived at the ICC, and you're claiming that it falls under, I will think, Article 20, subparagraph 3, and the exception will be B, which is otherwise not conducted independently and partially. But then, for me, what bothers me is the end. The idea that it was not done partially or independently, and were conducted in a manner which, in the circumstances, was inconsistent with the intent to bring that person concerned to justice, to bring them to justice. So for me, it's really the idea of have they been brought to justice, even if the process was impartial, because at the end there was a conviction. And so it's just, I'm wondering how you could approach it in a way that will be more sympathetic to the defendant. It could be used by the defendant in a way for people who are powers, like a state that is sympathetic towards that defendant, and that could be argued that, well, the ICC could prosecute the same case even though state A already prosecuted it, but state B disagreed that the process was fair in that case, if it makes sense.
Yeah, thank you. Another question from James.
Thank you for the presentations and the conversation. It's been really interesting. I was wondering if, in your view, the idea of nibis in idem has any relevance whatsoever for targeted sanctions. And I'm thinking in particular of this kind of rising trend of states to sanction individuals on the basis of asserting international criminal legal responsibility. So we see this often in the so-called Magnitsky regimes, but then also, especially in the context of the Russian invasion of Ukraine. For example, the EU sanctioned many Russian military officers, saying that they had perpetrated crimes against humanity and war crimes in the context of the conflict. So my question, does this have any relevance whatsoever? I mean, sanctions are often described as an administrative measure, but then people argue they have punitive effects. So yeah, just if you could comment on that.
So the first question, whether the unfairness of the domestic trial is a basis for a trial before the ICC, I guess that's the question. And that's a question that has been discussed quite a lot by scholars, and also the ICC discussed the issue in Al-Senussi admissibility decision. there are some scholars that argue that, the lack of fairness of the domestic trial itself renders the case admissible before the ICC. This was discussed specifically not in the context of nebis in idem, but other admissibility provisions, Article 17, paragraph 2. But this wording of this provision is similar as the exceptions to nebis in idem. And in my book, I take the view that the lack of fairness itself is not a basis for a repeated trial, or does not give the ICC the competence to retry the case unless there was intent to shield the person from accountability. So to bring the person to justice, in my understanding, is to bring the person to accountability, to hold the person accountable. And I'm not... One of the reasons for me is that that position is not necessarily sympathetic to the defendant, because you subject the person to another trial, costly, lengthy, for the purpose of giving the person another better trial. There is nothing in the statute of the ICC that actually allows adding this other exception to a nebis in idem protection, and I don't think it should be. And it's not the function, in a way, by the court, and that's something the ICC says in the Al-Zanussi decision. It's not the function of the court to enforce human rights at the domestic level, even though human rights are applicable in the proceedings before the court itself. And the questions about relevance to sanctions, nebis in idem applies when there has been a criminal trial. So in human rights standards of nebis in idem understand what is criminal quite broadly. So an administrative sanction that complies with a certain criteria of what is criminal can also be considered for the purpose of nebis in idem. But I don't think the type of sanctions that you described itself trigger the application of nebis in idem principle.
Guyana's being a bit modest, because in the first question she spends, I don't know, about 20 pages actually. Is very, very convincing. But also, no, this was directly addressed by the court, but the court came to an extraordinary decision. It agreed with absolutely everything Guyana said. It said, bring to justice, look, if you speak to any English speaker, it means to put them before a court to try to get them to go to prison, okay? Otherwise, you're just interpreting it contrary to its ordinary meaning, and indeed probably in bad faith. They say we are not a human rights court with a general, review function. It goes through all these things, drafting, blah, 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 and then it says, unless it's really bad. Unless it's really bad, then the meaning of the whole thing changes. So the same words can have a different meaning in the same provision. It's just nuts, So yeah, but it's exactly right. It's a live question.
Please. We still have a few minutes, so...
on this point, the court says if it's generally, if it's egregious, but that means that that the same treaty, terms of the treaty have different meanings depending on the circumstances, which is contrary to the basic rule of treaty interpretation, that there is one authoritative meaning of a treaty. So that's the argument I make in the book.
Do we have, maybe we can take one last question, or we can let Mary respond. I think we do that.
I think you can do both, because I just wanted to add and highlight that I do think the sanction question is something that needs to be worked out, because you also discussed this, because administrative decisions can have really punitive consequences. And I'm thinking, too, after acquittals, you're barred from refugee status, for example. There's another that could be an administrative decision. You bring up the Bemba case, and the challenge as far as the ability to run for office, things like that. There are consequences even after acquittal, and so again, defining this better, I think, will help define, which are falling within a nebis, even when they are quasi-administrative or quasi-judicial or somewhere in the middle.
It's not a question, because I'm focused on nebis in idem international criminal law. I don't go into the in-depth discussion about what are the types of sanctions at a disciplinary proceeding or administrative proceedings, whether nebis in idem applies. But there is a recent publication, I think, on this specific issue of kind of the double-tracked proceedings. If you have the administrative trials, for example, tax proceedings, and then the criminal proceedings, and in what circumstances this could engage nebis in idem, for example.
Just about sanctions themselves, I mean, even the European Court of Human Rights says, I mean, they're not penal. They're preventive. And of course, after 20 years, when you don't have your hands on your bank account, you may question that. But strictly speaking, they're right.
I think I'm in the unfortunate position to end this discussion, and I'm sure there's still many questions, and there's many questions that we still need to address, I think, in scholarship and in practice. So that is also a good takeaway for anyone looking for topics to work on. I'd like to thank all of you for being here. I thank you, Gayan, for having the idea and promoting it and then coming over. I'd also like to thank our co-organizer, IHCL Platform, our events team that maybe hear me through the microphone, as well as our IT support team, as well as Konstantina for helping out with the microphone, and of course for all of you for attending, for having questions, and for spending your evening here on these difficult questions of law. And I wish you all a nice evening. Thank you.